Good evening, Facebook friends. I'm attorney Alma Rosa Nieto. It's good to be back. We missed only one Tuesday, and we're back as usual every Tuesday, 4 p.m. West Coast, 7 p.m. East Coast time. And we were talking a little bit about getting your feedback and your interests and your likes about changing the time. And it seems like we're staying at 4 and 7 p.m. East Coast time. So just letting you know, I don't want you to be confused and saying, wait a minute, is it going to be Tuesdays at 7 p.m. and Thursdays at 7 p.m. in Spanish? No, we're going to have the English segment on Tuesdays at 4 p.m. West Coast time. And on Thursdays in Spanish, 7 p.m. West Coast time. So we're not going to change them to match. We're going to keep them the way they are for now. So just letting you know, because we did bring that up and I don't want you going, what time? So very nice to be here with you. I missed you last Tuesday. Believe it or not, I do miss my Facebook Lives. It brings me great joy to be able to communicate and talk with you and share information. And it brings me more joy to know that many of you are either writing me or calling me or seeing me in person in my office and telling me how much these segments help them to get some direction or to know something new. I had one person say that she went to another lawyer because she lived in another state and said, but she said, I saw an attorney on Facebook Live on Telemundo say that I could immigrate in the United States because my son is in the military. And that lawyer didn't know this. So that feels really good that because of what we're doing, we're able to give you like tools and weapons and arms to protect yourself and educate those that are supposed to be servicing you. So thank you. Also want to say thank you to so many people that watch us every week. And some people watch us Tuesday and Thursday. They're bilingual and they watch both segments. And we had a lot of people saying presente 2 Tuesdays ago, and I hadn't mentioned it on this segment in English, from Spain, from Uruguay, from Chile, from Argentina, from Mexico, from El Salvador, from all over, even the Caribbean. And that also feels really good that we're able to share immigration, U.S. immigration news and law, and that people are able to absorb it through this method of the Facebook Telemundo. And so that is also a great source of joy for me to be able to do this. So thank you. First topic, DAPA and DACA. Briefly, for those of you that don't know what DAPA was, because now it's a was, it was an executive order that President Obama passed to give a work permit to parents in the United States that were undocumented, that had children born in the United States, or they had green card, children with green cards. Then as soon as the president signed it, the courts attacked it, or the states attacked it, 26 states. Then it went to the courts in Texas, then it went to another court, a federal district court. Then it went all the way to the Supreme Court. Then it went back down from the Supreme Court, and finally this administration says it's over. We are rescinding it. In other words, canceling it, not modifying it. It is dead. So DAPA for parents that are, we're hoping they could get some kind of benefit because they've been here as good citizens for a very long time, had children born in this country or green card holders. That hope, unfortunately, is now gone. So that's DAPA with a P. Now there's DACA with a C, and that was another executive order that President Obama signed in 2012 that, as you know, many dreamers have taken advantage of. Almost 800,000 have applied, and that is they've been here for a long time, since they were children or very young, not young adults, but young in their adolescent years, 15 or below. They came to the United States, and they've been able to get work authorizations for 2 years and change their lives dramatically by either going to college or starting their own business or getting better jobs and Social Security, buying their homes, buying their first car. So that's been a wonderful law that has helped the country and has helped many individuals that are here totally I should say innocently, because they came as children. They had no say in where their parents took them, and they've been here all their lives. So DACA is still on the books. However, the administration has said they have a sensitive spot, their heart goes to the young dreamers, and they've said that they were not touching it now. Now, there isn't a strong message from the White House or from the executive branch, any of the executive branch members, saying that it will continue. What has been said that's a little bit of light and positive for you to share to others is that, and if they decide to cancel DACA, let's say in a month, in a year, in 2 years, that anybody that has it and has a permit that has another 2 years of life or another year, a work permit, that they would honor that. So let's just say, just to make up a date here, that on December 1st of this year, they canceled DACA, and someone just got their work permit, a new one, and their renewal for 2 years. That young dreamer would still have his work permit for another 2 years, even though the program has ended for reinscription for new applicants. So that's the only good news we've heard, the two pieces of good news. One, that it's DACA continues. Two, that when they cancel it, if they do, people will continue having their work permit until it expires. But I'd like to hear from the administration a strong, resounding, we're not touching DACA until Congress comes up with a better solution. That we have yet to hear. So we're still all with this big signal or symbol of question mark, wondering when and where, when is this going to happen, or when are they going to cancel it? So unfortunately, dreamers are still concerned, still nervous, still worried, still maybe having sleepless nights, not knowing their future. But at least the good news is that if it does get canceled, nobody's going to be deported immediately, or they're going to lose their work permit that day. They would still live out the life of the permit. So that's the good news. Anyway, I've said a little bit about this last week and Thursday in Spanish, but since we were dark last Tuesday, and this is my first time with you that watched the English version, I wanted to make sure that that was understood. The rescission is only for the DAPA for parents, but the DACA for youngsters continues. So that's the good news. Let's take questions, and then I have a really, really important topic on U visas that are there's a twist to it that very few people know, and many could still get a green card through. So stay tuned. As soon as I take some questions, I'll go into that topic as well. So let's start with our questions, please.
The first question is from Gabriela Romero. I came to the U.S. when I was 15 years old. When I was 16, my parents applied for political asylum. Now, they both have driver's license and social security cards and are able to work in the U.S. They're considering moving out. I'm now 18 years old, and I want to know if I could stay here legally without them being present.
Well, yes and no. I don't know what state you live in, but most states require you to be 18 to be an adult. Now, they could very well leave you with someone, a parent or a relative of theirs, or it could even be a friend, but they're going to have to leave some kind of legal document that is enforceable in the state in which you live in that allows that person to make decisions for you, like it would be enrolling in school, showing up for teacher-parent conferences, medical attention if you were to need it, or some kind of surgery. So that person becomes like your guardian, and this way you can stay. Now, that's a state law. It's different from immigration. Now, you tell me about your parents and their status, but you don't tell me if you've applied for DACA and have some kind of status in the United States, or also are a derivative of their asylum application, and you also have a work permit through that means. Now, let's assume the latter, that you have a work permit through their asylum. I would want you to apply for DACA before your parents leave, because if they leave the country, or they're leaving wherever, and they're leaving you here, well, of course, the asylum application would die, and if you are a derivative, meaning you fall under their application, well, then your application for continued work authorizations would be denied as well. So again, if you didn't apply for DACA, go ahead and apply now and seek counsel from an attorney to see what the best route is. But those are my recommendations, that you have some kind of state protection because you're still a minor. Now, if they can wait till you're 18, that's perfect. Then you're emancipated and you can stay on your own without a problem. But that only alleviates the legal aspect. I want you to also have some kind of immigration status as well. Oh, I'm sorry. Okay, yes, I'm sorry. Those of you that are watching, I'm getting a message here. Message is to remind you that we also do this in Spanish, and the reason we do this in English is because immigration laws in the United States are a topic for Asians, Africans, Europeans, all of Latin America, and there are many Latinos that are married or in partnership or have a relative that maybe supports them or loves them that do not speak Spanish, and they want to understand, because they love that person that maybe has immigration issues. They want to understand how to help them. Some of the millennials don't speak good Spanish. They speak mostly English. They want to know how to help their parents, or how to help their girlfriend, or how to help a sibling that maybe is older than them and they're 21 and they don't understand immigration laws because they are highly complex. So this is why we do this in English. We also do it in Spanish on Thursdays. So, en español también todos los jueves, no olviden, empezamos en español y seguimos en español. Lo de inglés es reciente, apenas unos 4 meses, y lo hacemos con el fin de que toda la población, hable en español o no, aprenda de derecho migratorio y puedan hacerme preguntas y espero poderlos guiar. Así es que martes en inglés y jueves en español.
Thank you so much for clarifying that. And our next question is from Francisco Mayorga. How long does it take to get a green card when you marry a U.S. citizen? Can you please explain the process or steps for me?
Very well. It depends. There are 2 processes that are quite different. If the person that marries a United States citizen, so say the person that does not have a green card, entered the United States legally or has a protection of a law called 245I or has a wife that was in the military or is in the military or children in the military that are adults, they can immigrate in the United States, and the process merely takes 6 months. It's a very simple process, and it's all done in the U.S. without the need for waivers or pardons, without having to travel abroad to the American embassy and take risk of not being able to come back. Now, if that same person that wants to get a green card entered the United States without documentation and has been here for a long time, that person has to immigrate through his U.S. citizen wife in his home country. Let's just make up a country for now, Guatemala. They would have to go back to Guatemala, have an interview with the American consul at the U.S. Embassy, and then decide if they can come back. That process takes about 1.5 to 2 years because the person that wants to get a green card also needs a waiver, a pardon for living here illegally. So the process is way more complicated, way longer, and very costly. So there are 2 processes. Just because someone's married to a United States citizen, it doesn't mean that the paintbrush is the same. There are 2 jurisdictions that are completely different, and the time and the cost and the process is very different.
Antonio Sosa. My son has DACA and will marry an American citizen soon. He entered illegally when he was 6 years old and got DACA when he was 17. Is the 10-year penalty applicable to him?
Well, the 10-year bar, great question, because many people don't understand the bars. The law basically says if you lived here after you reach the age of 18, you could get here at 1, but if you're from 1 to 17 illegally in the United States, you don't have that penalty. But as of age 18, it's like the clock starts ticking. So if this person got DACA at age 17, he has no illegal presence, because from 2 to 17 doesn't count. At 17, he gets DACA. He has some kind of legal status, albeit temporary. And then now he's going to apply through his wife. So he has 2 options: to get an advance parole and leave back home and come back in legally to then immigrate here in the United States, or go back to his home country and immigrate, but he'll be there a few days and he won't need a waiver because he hasn't accrued illegal presence. Now, I need to know a lot more. Have the parents ever taken this child in and out of the country? There are a lot of other issues. I'm just dealing right now with the penalty of the 10-year bar because someone's lived here illegally. There are other bars that come into play. So again, this is basic information. It gives you enough to go see someone, as I said at the beginning, that went to a lawyer and they didn't know about this law that I talked about. And this client educated the lawyer, who then read up on it and says, oh yeah, we can immigrate you here. So it's a guidance. It's just at least a light at the end of the tunnel so that you can still do your research. And of course, a lawyer needs to interview you at length to find out. There's so many details. I've had so many clients before me that tell me, this is my brother and we're siblings and our case is exactly the same. So we want to talk about our case. And I start interviewing one, then I get information from the other, and the cases are black and white. They're totally different, just for few factors that they don't think are important, but a lawyer knows are. So again, seek counsel.
Christina Garcia. I'm a U.S. citizen, and my husband and I have been married for 10 years. We file our taxes separately. Is that a problem to help him fix his legal status?
Great question, especially since tax season just ended, and those of you that are planning taxes next year, hopefully with this advice will know what the right way to do, what the right way to file is in a case. I don't require that a couple have taxes together. I like it. If somebody says, I can do them separately, I can do them with my spouse, I will always choose to do them jointly or file separately as married. Immigration looks at taxes for a number of reasons: to see if you're paying them, to see if you commit fraud in them, to see if you make enough to get a green card or be a sponsor to someone that's going to get it. And they also look at it in marriage cases to see if this is a real marriage or it's just a marriage for convenience to get a green card. So if you tell me that in your 10 years you've lived apart, you have no children, you have nothing together, you've decided that he maybe is irresponsible financially and you have all your bank accounts separately, your credit cards separately, your taxes separately, that consul is going to say, I don't care if you've been married 10 years, this is a little strange. You have nothing together. I don't think this is a marriage for love. I think that maybe you're good friends and you've been married all this time and you're just accruing time to later immigrate. Believe me, they do think this. So it depends on each case. Now, if you tell me we've been married 10 years, we have a house together, we have credit cards together, we have bank accounts together, we just file our taxes separately. But as married, if you file your taxes separately, a single big red light, an alarm, an alert for the consular immigration, you're saying here that you're not married, that you're single. And so are you married or not? It'll open up a lot of questions. So again, we'd have to look at all the factors in your case to decide if maybe next year you should file together or you can continue to file apart. But I've given you kind of the tips and the warnings and what makes a consul go, okay? Very well, the second topic, which I know many of you are waiting for because it's important and maybe it might not be you, but you know someone. I always say, please share this information. I hope you can be a beacon and light for other people and say, hey, I heard this, and maybe somebody will say, I better go see a lawyer, this might help me. Well, the U visa was created by Congress. It's still alive and well, no changes even under the new president and the new administration. This is something Congress did, not Obama. He didn't sign an executive order. And Congress basically said, if you are here undocumented and you're a victim of a violent crime and you report it to the police and you cooperate with the investigation, either with the police or with the DA or with the court, we will give you a green card if you apply for a U visa. Now, this law has been around now for several years, and thousands have immigrated because of it. They got their U visa first, then they got the green card. However, in asking people, many people have said, no, nothing's ever happened to me. I've been here for all this time. Nothing's happened to me, to my husband, thank God. Nothing's happened to me. But then as I start to talk about their children, and many of them are born in the United States, some have been victims of violent acts. They were either kidnapped, there was sexual molestation of the child, maybe in daycare, in school, or of a relative. They've been beat up, they've been bullied, they were on their way to school and they were robbed and they were hurt and hit because they wanted to steal their cell phone or their lunch money, whatever. So many times a child that's born in the U.S. has been a victim of a crime, and if the parents are here undocumented, guess what? Those parents, although nothing's ever happened to them, they can apply for a U visa and derive the benefit and get a U visa and even a green card if they can show this. Now, it can't just be, yeah, something happened to my son and we were so embarrassed, so ashamed, we were so shooken up by it emotionally that we didn't do anything. That won't work. It has to be, Congress pretty much said, show me that you're helping to get bad guys and criminals, and we'll give you a green card if you're a victim of a violent crime. So if you just zipped it and didn't do anything, we can't use that. But if you reported the crime against your child, whether they be undocumented or citizens of the United States, but they were minors, then the parents, or a single parent, if they're raised by a single parent, can get a green card. So this is very important. Many people don't know this. And sometimes maybe the child that was hurt in some way was, let's say 10, but they have older brothers and sisters that were 12 and 16, and they are here undocumented. Well, guess what? That child that suffered some kind of harm to him or her will be able to get a U visa for the siblings that are not legal residents or citizens, and the parents. So this is a law that I like to put it as, I love analogies. I'm sorry, I think it's easier to understand some of these hard concepts sometimes. And I always think that it's like throwing a pebble in a pond. It has many ripples, and so is the U visa. It doesn't just have to happen to the applicant. It can be to some of the relatives around the applicant that are immediate family. So make sure that when you see a lawyer about U visa, you in your mind have a history of your family and of what's happened so that the lawyer can decide who has the strongest case. I've had couples come to see me for a U visa, and they've both been victims of a crime, and they both bring the police records, and they both think that they also have to apply each individually. I said, no, 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 you don't have to spend double the money, just one application. So if I decide that the husband had the stronger case, I'll say to the wife, we're going to apply through your husband, and you will also get the same benefit, and you pay one fee, not two, but I choose the strongest case. So if maybe a parent has been a victim of a crime, but so is his child, take both records from the police, from the DA's office, from child services, from the court if there was a conviction. Take all of that to the lawyer so that the lawyer can evaluate and tell you who has the strongest case, because we want to do a sure shot. We want to apply one time and get approved. So that's a topic of the day. I know that unfortunately in these trying times, so many things, especially under this new administration, and for people of color, there have been a lot of crimes that are crimes of hate, and if you don't report it, and you're here undocumented, not only is this going to be perpetuated, but you don't get a benefit that is there for you by Congress, which is to get a green card. So you must report it.
Maria Carrillo. My husband was protected under 245I, but then signed a voluntary departure, and he never left. His form states he was detained for over 24 hours, but was not. Instead, he was released at El Paso border within a few hours of being detained. Is there anything we can do to fix his papers? I'm a U.S. citizen and we have 2 children.
Good. The first thing I would do, or 2 things I would do before deciding anything, you have to investigate. You have to know more. You have to dig in and find out. Anybody that says, oh, yes or no, without doing some investigation work, they just want your money. And they're not really giving you good advice, because we don't know what happened way back then. I hear your story, but I need to see what's in the file. So first thing I would do is run his fingerprints and send them to the FBI. And the second thing is I would do a FOIA from the border. It's called U.S. Visit FOIA. Or from the court, if he had a court case, whoever had the last case with immigration. This way I can see what happened to the case. If it was voluntary departure and it was granted by a judge and he didn't leave, unfortunately, a voluntary departure means a judge says, I know you're here illegally, but I'm going to let you leave on your own. You pay your way, you leave by a certain date, you promise not to come back unless you have a legal way to coming back. That's kind of like a privilege. I know you're being taken out, but at least it's not an ugly mark on your file that later prejudices you. But they got wise and they said, wait a minute, a lot of people aren't leaving. So now we're going to say, if you have voluntary departure and you ignore the order and you stay, it'll automatically turn into a deportation. So we don't know if that's happened in your husband's case. And I know you mean well for him. You're a citizen. You want to get his green card. You want to get him fixed in the United States. But sometimes it's best not to move anything or do anything because you'll hurt him. So best to do the investigative work first, and then a lawyer can review it, or the lawyer can do it for you, and then we can decide if you should apply for him or you should just stay put until he has another form of relief, or maybe he can reopen the case with the judge, the immigration court, but those are tricky. So all of that analysis has to be done with some investigative work first.
William Mencos. I got a petty theft misdemeanor, which I already took care of. This petty theft issue happened about 10 years ago. I also have 2 prior traffic tickets that were unpaid from about 8 years ago, and I recently checked for any warrants that I don't have. I'm a resident card holder. Could I face deportation? Last time I traveled was in 2015 when I came back from Los Angeles.
Excellent question on many grounds. The fact that you traveled recently doesn't tell me anything, because that was under Obama. You have to tell me if you've traveled from January 20th to date, because that's when they're really clamping down on entries and they're checking people's backgrounds and putting people under deportation proceedings. So the fact that you traveled in 2015 doesn't say anything to me under this new administration. Second, a petty theft is usually something very minor, but again, I'm not saying you don't know what you were charged with, but just like I don't know everything about tax laws, and I have a tax preparer do my taxes, my corporation, my individuals, because they're complex areas and I don't want to make a mistake. I would want you to have that checked, that crime, with an immigration attorney and make sure it's classified as a petty theft. Sometimes you hear negotiations with the DA, with your lawyer, the judge, and they're using the words petty theft, but in fact, when you look at the penal code in your particular state, it's not a petty theft. That's not how it ended. So we want to make sure that it's a petty theft one. And you said you have a couple tickets that weren't paid, but you checked that there are no warrants. That does not make me happy at all. For citizenship, I always tell people, and allow me to use my hands, for residency, they check from here to here. For citizenship, they check from here to here. Yeah, like double or triple. So the fact that you made an investigative inquiry about warrants and nothing came up doesn't mean immigration won't see it. So I would like you to seek criminal counsel to go check and make sure that in the courts, and you get something that says that there's nothing in those jurisdictions where the crime or the traffic violation occurred, so that if you apply for citizenship, they say, hey, you have a warrant. No, we checked, and here's, at least it shows that you did everything you could to clear that, and that the courts told you you didn't have anything, or the police. So there's some work to be done in your case.
And this is the last question from Aida Flores. Why is the I-601 taking so long? I submitted the form on February 2016, and I have not heard anything from UCIS.
Okay, well, everything, I've said this before, is taking a lot longer with USCIS. Under this new administration, many people have been under fear. They're afraid if they're residents, they're becoming citizens, so citizenship's taking longer. If they had no paperwork at all, they're now filing for residency because they're afraid. So everything is backlogged. Now, the I-601 normally takes between 6 months and a year. I don't know if you've got RFE, that means request for evidence. That'll make it take longer because they've asked you for something else by the time you sent it. It went kind of to the back of the line, and now they're going to review it. And some cases take longer because they're investigating them. They're looking at everything you wrote down. Our I-601 waiver packets, that's for unlawful presence, are this thick. And sometimes they want to talk to the client again, they want more information, they're investigating your file with immigration, they're investigating to see if you have no priors. So every case is different. This is just a little over the year mark. You said February of 16, so March, April, May, June. You can file an inquiry, so whoever's filing the I-601 waiver for you should prepare a cover letter and say, you know, this case has been pending for a long time, please give us a status, what's wrong, do you need anything else? Can we submit any other evidence to help you to make a decision in this case? I would do that to kind of make them hurry up.
And we do have one more question. I know I said that was our last one, but it's from Peque Perez. Her question is, my mom brought me when I was 14. We arrived at the U.S. June 13, 2007, but I have no proof of that exact date. What can I do?
Wow, those are tough cases because immigration wants to know that you were here on a certain date and that you were here before you turned 16. So there are two key dates in a DACA application for a youngster that came here underage. That you came here before you turned 16, so look at your birth date and whatever evidence you have before you turned 16, you know, vaccinations, you went to the doctor, you went to the dentist, they enrolled you in school, they enrolled you in ESL, anything that has your name and that has some kind of seal or proof from the United States would help. Now, the other thing they want to know is that you've been here from 2010 and on, so in this case, you need that evidence too. If you don't have any of that, it's always risky to apply because you have to pay for a fee with immigration. If you get denied, you're going to lose it. And in some cases, and especially nowadays, I'm afraid that they might say, you're denied and thanks for your information, and now we're going to send your information to ICE. It's unlikely. They usually do it with someone that doesn't qualify because they have crimes. But I would make an appointment with an attorney to go, you know, attorneys, we've been trained for this. We're like investigators, right? So we'll ask so many questions that maybe it'll trigger something in your mind that says, oh, I hadn't thought about that. That's right, I was 15 and I was babysitting someone and they were a family from the United States and maybe they'll give me a letter verifying and maybe they paid me with checks, maybe they have copies or they can ask their bank for copies. So seek counsel because you may think you have no proof, but somebody that's interested in your case and in you will really scratch beyond the surface to see what other evidence could be presented in a case before you file. Well, that was the last question, Peque. Thank you very much. Thank you all for continuing to watch, for watching both segments, for watching us all over the world, for sharing this information, and for telling friends and family and those people that you care about that this exists on Tuesdays in English, on Thursdays in Spanish. We'll see you next Thursday for those of you that want the Spanish version at 7 p.m. West Coast time, 10 p.m. East Coast time. Hasta la próxima. Bye-bye.